past recollection recorded is really a matter of evidence law, and it's a hearsay exception, which basically says is that if a witness once had personal knowledge of an event or a fact or an occurrence, but does not recall it now for whatever reason, passage of time, or maybe the person suffered some type of trauma that affected his or her memory, whatever it might be, but doesn't recall it now, but made a memorandum of the event or a record of the observation at the time, or conveyed that information to another person, say a police officer, and that person wrote it down. But as it turns out, that memorandum or record of the observation or the event does not now refresh that person's memory for whatever reason. If a foundation is laid and if it's properly set forth, you can admit that prior memorandum or recording, not as a substitute for, but as a supplement to the witness's testimony, so that a jury could consider the testimony and that prior writing as if that writing had come from the witness based on present recollection. Daisy next door is chiming in here. I don't know if that means she agrees or disagrees, but hopefully it's in agreement. So the witness had personal knowledge of the event, but does not recall it now, but the witness either made or conveyed information that was reduced to a memorandum or a record, but the witness's memory does not now refresh. And so if a couple of things are satisfied by way of foundation, that prior record now can come into evidence, substantive evidence for what it asserts. And the two key factors to keep in mind here is that when that memorandum was made, or the record was made of that information or observation, that it was at a time when the witness's memory of the event was reasonably and fairly fresh. It can't be too removed in time from the event because it may not be accurate anymore. So it's got to be fairly close in time to the event that was recorded. And second of all, that memorandum or record must be an accurate or correct representation of the witness's knowledge and recollection at the time that memorandum was made. So if those foundational building blocks are properly laid into place, then you can actually introduce that recorded recollection into evidence as a supplement to the witness's testimony. There is a case from the Court of Appeals, People versus Taylor, 80 New York 2nd, 1992, which addresses this issue of past recollection recorded and the importance of the foundational elements, in particular that the record be an accurate representation or recordation of what the witness observed. And it's important, first of all, to keep in mind that that prior record doesn't have to be prior sworn testimony. It can be in the nature of a written note. It could be, I guess, a recording, an audio recording, or it could be a police report. So it doesn't have to be generated by the person who is the source of the information, but it must be timely and accurately recorded. So anyway, in People versus Taylor, this involved a defendant who was charged with separate acts of sexual assault occurring within several days of each other, involving separate victims. In one instance, the defendant went into the home of the victim and raped her at gunpoint. In the other one, it was an attempted rape at knife point. So both victims eventually identified the defendant in separate lineups. But the issue in that case, or one of the issues, was the admissibility of a license plate number that had been conveyed by a neighbor's daughter to police. And here's what happened. In that case, about 3 weeks after the assault at gunpoint, a young woman was visiting her mother. Her mother was a neighbor of the victim. And she testified that there was a man who came to the victim's doorway, was knocking on the door and asking for a woman named Cindy. Well, as it turned out, the name Cindy was the name that the victim had given to the defendant. It was not her real name, but she gave a fake name to protect her identity. So she said the individual was knocking on the door, nobody answered, so he left, went outside and got into a car and took off. And she wrote down a license plate number which she conveyed to the police. Well, her mother testified that no, actually what happened was I wrote down the license plate number, gave it to my daughter, who in turn relayed it to the police. Now, when the daughter called the police department, she spoke to a detective who was not assigned to this particular investigation but happened to be on duty, and this detective apparently wrote down the license plate number on a memorandum or note paper, which he then in turn conveyed to the investigator or detective who was actually working the case. That detective in turn took that license plate number, ran a plate check, and it came back registered to the defendant. So that evidence linked the defendant. Daisy, I'm in the middle of something, if you please. So it linked it to the defendant as the person who was knocking on the door and who that witness believed to be the rapist, and who was identified by the victim as the rapist. So the trial court admitted that license plate number through that memorandum into evidence, and also allowed into evidence an uncertified copy of the defendant's registration information. But here was the problem. The witness, the woman who conveyed the information to the police officer, testified, well, this was a year later now at trial, she says, I really don't remember what the license plate number was, and I don't have the note paper that we wrote it down on, so I don't remember what it was, but I did convey it to the officer. Now the officer or detective who took the information testified, well, honestly, I don't recall receiving this message, and I don't remember writing it down, but I can tell you that this is my handwriting on this note paper that I then gave to my fellow detective, and I always had a habit of writing things down as accurately as possible when it was conveyed to me in that fashion, but that was the best that detective could do. And so the trial court let it in, the appellate division affirmed the conviction, and the Court of Appeals reversed, saying that although the information with respect to the license plate was timely received and recorded, because within minutes of seeing the car and the license, the witness called the detective, so that was not an issue. The problem was verification of the accuracy of that information, because the witness herself did not recall the license plate number, and she said, well, as far as I know, I conveyed it accurately to the detective, but she never had the detective read it back to her to make sure that he accurately recorded what she conveyed to him, nor did he say to her, okay, I'm going to read this back to you now, and is this an accurate reflection of the number that you just gave me? So the number was not verified. So that second prong of the foundation, that the memorandum or record correctly represents the witness's knowledge and recollection when it was made, was not satisfied. And the Court of Appeals said that admitting that information into evidence in conjunction with that unverified or uncertified record which connected the defendant to the crime scene constituted reversible error, because the evidence was not otherwise overwhelming in its own right. So I hope that gives you some clarification of the difference between refreshing recollection or present recollection revived. Mother Nature's taking over here. Present recollection revived versus past recollection recorded. One is simply a means of helping your witness recall something that he or she has forgotten. The other is to introduce a written memorandum or record of something that the witness once knew and recorded but doesn't remember now. It was done timely and it was accurate. So if you get those things in line and in place, then you can get that into evidence. So I hope that's helpful, and I look forward to speaking to you again. Hang in there, everybody.